Hey everyone, welcome to this explainer. Renting a home can sometimes feel like you're stepping into this huge power imbalance, right? Like you're just totally at the mercy of the property owner. But guess what? The reality is actually quite different. Today, modern contract law gives the roughly 44 million renter households here in the US some incredibly strict statutory shields. We're going to break down exactly what your housing provider is legally barred from doing. Seriously, no matter what crazy clause they sneaked into your lease.
So let's kick things off with a high-stakes scenario. Picture this. You fall behind on your rent. It happens. But can a landlord legally just show up today, change the deadbolts, and lock you out without a court order? It's a terrifying thought and honestly a super common misconception. Well, spoiler alert, the definitive answer is no. Despite what a lot of people believe, landlords absolutely cannot bypass the courts and take the law into their own hands. No way.
Here is our roadmap to your renter protections. We're covering 5 absolute legal boundaries today. No self-help evictions, privacy violations, deposit exploitation, ignoring essential repairs, and illegal landlord retaliation. Let's dive right in. Boundary number 1, no self-help evictions. Bypassing the court system is entirely illegal. Here's the deal. The only lawful method to remove a tenant is through a formal, usually pretty slow, court eviction process, an unlawful detainer that culminates in a lockout executed exclusively by a sheriff. Not the landlord, a sheriff. Listen closely to this. Even if a tenant owes thousands in rent, has completely damaged the property, or has been verbally abusive, taking what the law calls self-help shortcuts, like shutting off the heat, taking the front door off its hinges, or swapping the deadbolts, is strictly illegal across all 50 states. A tenant's bad behavior literally never justifies a landlord's illegal self-help eviction. And honestly, the law has some serious financial teeth here. States do not take this lightly. Take California, for example. Under their civil code, landlords face a minimum statutory penalty of $100 per day for every single day a tenant is illegally locked out or has their utilities cut. And yep, that is on top of covering the tenant's actual damages and attorney fees. Talk about an expensive mistake. Now, you might be thinking, well, what about those notoriously landlord-friendly states? Well, check this out. Even in Texas, where, incredibly narrow rent delinquency lockouts do technically exist in the property code, there is a massive catch. If the landlord locks you out, they have to leave a note, and they must give you a new key immediately upon your request. And that's regardless of whether you pay the past due rent. If they refuse to hand over that key, they face harsh penalties of 1 month's rent plus $1,000.
Moving right along to boundary number 2, privacy violations and the covenant of quiet enjoyment.
Basically, this boundary translates to your absolute legal right to be left in peace and to use your home without unreasonable interference. Unless there is a genuine, life-threatening emergency, like water pouring through the ceiling from an upstairs unit, landlords cannot just pop in unannounced. Notice periods definitely vary by state, from 24 hours restricted to business hours in California to 12 hours in Florida or 2 full days in Washington, but that baseline protection of your privacy exists everywhere. The really crucial point here is that a lease contract cannot just magically erase your right to privacy. Things like highly restrictive guest clauses that force you to register a buddy crashing for a single night, or a landlord slapping a realtor's key lockbox on your front door while you still live there, those completely circumvent your privacy rights. They are legally barred. Your landlord also cannot harass you at your workplace over non-emergencies or hand out your financial data without permission. It's a huge no-no. All right, boundary number 3, deposit exploitation. Normal wear and tear versus actual property damage. So here is a reality check for some property owners. Your security deposit actually remains your property, held in trust. It is not a landlord's slush fund for routine property maintenance and upgrades. This is exactly why it's absolutely vital to document your home's condition with highly detailed move-in photos. A landlord cannot legally deduct a single dime for natural, unavoidable deterioration. Faded paint from sunlight, minor scuffs on the wall from walking by, loose hinges. That is just the cost of doing business. Deductions are strictly for actual damage caused by negligence or abuse. We're talking giant holes in the drywall or deep pet scratches on hardwood floors. On top of that, courts strictly enforce what are called useful life rules. Basically, building materials have a legally recognized expiration date. Say you live in an apartment for 3 years. A landlord generally cannot charge you to repaint the walls when you leave because the paint has already reached the end of its useful life anyway. Similarly, they can only charge you for the depreciated value of an old, ruined carpet, definitely not the cost to buy and install a brand new one. Let's hit boundary number 4, ignoring essential repairs and the implied warranty of habitability. Every single residential lease comes with this implied, non-waivable guarantee that your home will be safe, sanitary, and structurally sound. We're talking a solid roof, working heat, and a pest-free environment. But what happens when the roof leaks and your landlord goes completely silent? Well, first off, do not just withhold your rent on your own. That can easily trigger a legal eviction for non-payment. Instead, you want to use the rent escrow process. By petitioning the local court and paying your full rent directly to the court clerk, you remain perfectly protected from eviction. Meanwhile, a judge essentially holds the landlord's money hostage until they actually fix the physical defect. It's incredibly effective.
And that brings us to boundary number 5, illegal landlord retaliation and the whistleblower shield. The law totally recognizes that tenants might be terrified to report a health code violation or maybe join a tenant union out of fear of being evicted. That is exactly why the whistleblower shield exists. Consider the 180-day shield used in states like California. If you report black mold on day 1 and the landlord suddenly hits you with a massive rent hike or a termination notice on day 90, the law automatically presumes that's retaliation. During this window, the burden of proof completely flips onto the landlord. They actually have to prove they have a legitimate, good faith business reason for the eviction that has nothing to do with you blowing the whistle on slum conditions.
And the cost of getting caught retaliating is incredibly steep. If the landlord fails to prove a legitimate business reason, they face devastating statutory penalties. Depending on your jurisdiction, this can mean up to $2,000 per retaliatory act, and that's on top of paying for your emotional distress, your actual damages, and your attorney fees. Ouch. When you boil it all down, the implied warranty of habitability sets a floor, not a ceiling, for rental conditions. A landlord doesn't have to provide a luxury penthouse, obviously, but the rental absolutely must be safe enough that a reasonable person can live there without worrying about their physical safety. You might not be entitled to fancy marble countertops, but you are absolutely entitled to a safe, private home, and a landlord who actually plays by the rules of the court.
I want to leave you with this one final, pretty provocative thought. Knowing your rights, that's really only half the battle. Proving them is the other half. If your landlord crossed a legal boundary tomorrow, would you have the move-in photos, the certified mail receipts, and the written repair requests ready to defend yourself? Start keeping meticulous records today and definitely explore more of our explainers to solidify your understanding of your legal rights. Stay informed out there and stay protected.